Hello and welcome to the Ncbp 21st Century Lawyer session on official regulated state bars. I'm Joe Sullivan. I'm a past president of the State Bar of Montana and the current secretary of Ncbp. First, I want to thank the State Bar of Michigan Executive Director Janet Welch. She will be giving us a history of official regulated state bars, otherwise known as mandatory, integrated, or unified bars, as well as the status of lawsuit challenges against these bars. So first up, I would like to welcome Janet Welch, Executive Director of the State Bar of Michigan. And she's a leader in understanding regulated bars, their history, and their challenges. I've had an opportunity to work with Janet on other presentations, and I can't think of anybody else who has as much knowledge about this topic as Janet does. So we'll start with a video dealing with that.
Good morning or afternoon, whatever the case may be where you are. I am Janet Welch, the Executive Director of one of the 33 official regulated state bars we're talking about today, Michigan's. And my assignment is to lay the foundation for the interactive discussion about the current status of official regulated state bars that follows. First off, a little explanation about the title of this program. The state bars in question have been called interchangeably mandatory, unified, and integrated throughout their 100-year existence, beginning exactly a century ago in North Dakota. The controlling U.S. Supreme Court's 1990 decision, Keller v. State Bar of California, uses the term integrated, which the Keller Court described as, quote, associations of attorneys in which membership and dues are required as a condition of practicing law, created under state law to regulate the state's legal profession. I personally like the term integrated because it captures the unique relationship that bars have to the state as a largely self-governing public entity performing a role defined not by themselves, but by the state for the public good. This is a framing that refutes the challenger's characterization of the official regulated state bars as non-governmental trade associations existing outside the state that the state forces lawyers to join. But despite the Supreme Court's adoption of the term integrated bar, the colloquial favorite is probably mandatory bar, which is negative and I think misleading framing, as all lawyers in the US are automatically admitted to a bar upon licensing and forced to pay some regular fee for the privilege of being licensed. For this program, Ncbp is trying out a new term, official regulated bar, a description that emphasizes two important aspects of the bars we're talking about, that they have an official governmental designation and that the public purpose of that designation is regulatory. So what bars exactly are we talking about? Here's a graphic view. The bars in the states in black are all official regulated bars. Pay attention to the two states outlined in red, however, starting with California, where the State Bar of California has been recently reconstituted to look more like a state agency. The State Bar of California now consists of all licensed lawyers in the state who are required to pay license fees rather than dues, and whose status in relation to the bar is characterized as licensees rather than as members. That is arguably a semantic distinction, and one that other integrated bars, including my own, increasingly are trying to use to distinguish ourselves from private voluntary bars. But what makes the California bar change more than semantic is the governing structure of the new California state bar model. Rather than being elected by all those admitted to the California bar, the leadership is appointed from each of the three branches of government. In that regard, California is distinct from all the other bars in the black states, including those in the three other states, North Carolina, Virginia, and West Virginia, that, like California, have both an official state bar and a voluntary state bar. The second anomalous state bar, regulated state bar, is Nebraska, where lawyers since 2014 are required by law to belong to the State Bar of Nebraska, but are not required to pay dues to the bar, just licensing fees to the state. So that map defines who we're talking about onto what the current status is. Those of us in integrated bars have come to appreciate in the last few years how truly diverse we are. Although we all grew out of the same movement to upgrade the quality of legal practice in the country, and many of our governmental charters contain identical language, historical, political, and cultural differences in each of our states have caused us to evolve in really different ways. Some of us have a very limited role in the formal regulatory functions of admissions, licensing, discipline, and CLE. Others carry out all of those regulatory functions, and many operate in the space between those two poles in a diverse array of supportive or administrative capacities. Let me give some concrete examples. The states of Rhode Island and Wisconsin, for example, did not give their official regulatory bars direct regulatory functions, but the bars provide the backbone of the support of the state Supreme Court's regulation through member service programs, including CLE. On the other end of the spectrum, the official regulated state bars of Virginia, North Carolina, and California are responsible for all of the regulatory functions directly, while many typical associational activities are carried out by the voluntary state bars in those states. And the state bars of Washington, Oregon, Texas, and Florida, to name just the biggest, carry out all of the regulatory functions as well as associational activities. My own state bar, Michigan, is a good example of the bars that lie somewhere in the middle of this range. The Michigan State Bar administers the licensing database and handles administrative functions for the separate admissions and discipline agencies. We perform the character and fitness function of the admissions process at the direction of the independent admissions agency, but make recommendations only. We provide monitoring and diversion support to the Attorney Grievance Commission, but have no role in disciplinary decision-making. And because Michigan is not a mandatory CLE state, we don't have CLE programming. As striking as these differences in scope are, the regulated state bars are at least as diverse in how they handle the sort of expressive activities that Keller addressed: the adoption of formal position statements and the expenditure of compulsory dues or licensing fees in support of those positions, including for lobbying activities. Many integrated bars do little or no advocacy. Some have staff exclusively devoted to advocacy work, to carrying out the bar's express governmental mandate to aid in improvements in jurisprudence and the functioning of the legal system. Those of us that do engage in advocacy carry out our advocacy under varying and elaborate processes and rules, self-adopted or imposed by our state Supreme Courts. These rules and procedures have been designed to meet what each state views idiosyncratically as Keller's requirements. Despite our significant differences, what we regulated state bars all have in common is that we are all now subject to a constitutional challenge on how we carry out our publicly defined mission. There are two prongs to the First Amendment challenges today: freedom of speech and freedom of association. The freedom of speech challenge says that regulated bars impermissibly force lawyers to subsidize speech with which they might disagree, with an emphasis on compulsory dues and what they are used for. The freedom of association challenge says that lawyers are compelled to associate with an organization they would not otherwise join if not required to do so to be licensed as a lawyer. The freedom of speech claim has been addressed by the Supreme Court in favor of the regulated state bar model twice. In 1961, in a case in 1961 against the State Bar of Wisconsin, Lathrop, and in 1990 in the case against the State Bar of California, Keller. The US Supreme Court has never addressed the freedom of association claim. Here are the cases that you need to know about to appreciate the current status of regulated state bars in the face of these challenges. The first Supreme Court reference to the status of regulated bars came 5 years before Lathrop, not in an integrated bar case, but in a labor case, challenging an interstate railroad union shop agreement. In upholding the agreement, the court said, quote, On the present record, there is no more an infringement or impairment of First Amendment rights than there would be in the case of a lawyer who by state law is required to be a member of an integrated bar. Just a flat statement, no elaboration about why that analogy made sense. And 5 years later in Lathrop then based some of its reasoning on Hansen, and the bootstrapped analogy between unions and regulated bars was off and running. The Keller decision, 30 years after Lathrop, also analogized integrated bar dues to compulsory union dues. Keller suggested that regulated bars could avoid constitutional challenges by relying on a framework the court had laid out 13 years earlier in another labor case, Abood v. Detroit Federation of Teachers. Abood had upheld union shops for public employees, but trimmed union sales by prohibiting unions from using objectors' dues for purposes other than those related to collective bargaining. Similarly, Keller limited regulated bar expenditures using compulsory bar dues to purposes, quote, reasonably related, unquote, to the regulation of the legal profession and improvement in the quality of legal services. As the US Supreme Court grew more conservative at the turn of this century, speculation began to build that the Abood decision might be overturned, and the 2014 labor case, Harris, heightened that speculation. Harris explicitly foreshadowed the overturning of Abood, but Justice Alito, writing for the majority in Harris, suggested that integrated bars could be distinguished from labor unions because requiring the payment of bar dues is part of a larger regulatory scheme, including the promulgation and enforcement of ethics rules, and that states have a strong interest in allocating to the members of the bar, rather than the general public, the expense of ensuring that attorneys adhere to ethical practices. Since Harris, 8 state bars, 25% of regulated state bars, have been challenged on First Amendment grounds in the lead up to the US Supreme Court's long anticipated reckoning with Abood, which the court did indeed overturn 5-4 in a 2018 case, Janus v. AFSCME, whose principal author was Justice Alito. So here's where things stand as of July 21st. As you can see, the challenges have been spread through 8 of the 11 federal appellate circuits. The decisions so far have been overwhelmingly favorable to the regulated bar. The bar has won at the district court level in every case in which there has been a decision, and in every appellate circuit case in which an opinion has been rendered. In the 2 cases in which cert was pending before the US Supreme Court, Fleck out of North Dakota and Jarko out of Wisconsin, cert was denied. I apologize for probably mispronouncing Jarko, but that's my best guess. The Jarko denial came on June 1 and included a dissent by Justice Thomas, concurred in by Justice Gorsuch. Justice Thomas wrote that because Keller rests almost entirely on Abood, and Abood is no longer good law, if the Keller rule that allows the regulated bar to engage in expressive activity about the regulation of the profession and improvements in the quality of legal services is to survive, it has to be on the basis of new reasoning consistent with Janus. Just 2 days before the Thomas dissent was issued, there was a decision in the Texas bar challenge case McDonald in the federal district court. In holding for the State Bar of Texas, the judge took a different view from Justice Thomas. He wrote that Keller merely drew an analogy between integrated state bars and labor unions, and that Janus did not undermine Keller's recognition of the very different state interests in professional regulation and legal service quality served by integrated bars, echoing Justice Alito's language in Harris. Of course, we don't know why none of Justice Thomas and Gorsuch's colleagues joined them in dissent from the denial of the Jarko cert petition, or whether any of them might agree with the contrary view expressed in the Texas case. But the contrast is noteworthy. I think what it tells us is that a fault line that we have to pay attention to is whether the long-standing but thinly developed analogy between unions and regulated state bars holds the key to the future of regulated bars. Many of the defense and amicus briefs in support of the integrated bar zero in on the weaknesses of the analogy. But there's also a different developing line of attack on the integrated bar worth paying attention to. The challenge that is based not on the freedom of expression clause, that was the focus of Keller, but on the freedom of association clause. And that challenge threatens the very existence of the integrated bar model, including Nebraska's, where lawyers are not required to pay anything to the bar. And in this regard, I would advise everyone to keep an eye on Oregon. The State Bar of Oregon won a very strong opinion at the federal district court level in the Gruber case, but faced strenuous questioning on the freedom of association in oral argument before the Ninth Circuit in May. So to wrap up, despite a string of favorable rulings, regulated state bars are not out of the woods yet. U.S. Supreme Court challenges to regulated bars seem to come in waves. The first case, Hansen, was about 60 years ago. Keller was 30 years ago. Is there a 30-year integrated bar itch? If so, the resolution of this murky status is close at hand. Finally, I want to remind everyone that when we're thinking about the status quo and the changing status of regulated state bars, that regulated state bars are not only subject to constitutional challenge, they are also subject to political challenge. In a highly polarized political environment, integrated state bars could win in the US Supreme Court and still be in peril if their authorizing entity, the legislature or state Supreme Court, chooses to trim their sails or sink them altogether. Responding to these ongoing threats is sharpening and shaping the evolving self-identities of every regulated state bar, which makes programs like this so important, and I thank Ncbp for putting this on. And with that, on to our discussion.
Thank you, Janet. And to begin our breakout room discussions, all of you have been assigned to one of three rooms. Again, the three rooms are current challenges against regulated bars. Second group is ensuring all voices are heard by your board. And the third is what regulated bars can and cannot say. So now we'll go to our breakout rooms.
We could just all take turns in sharing ideas about what we can and cannot say. And I'll just, Sharon, you always have excellent comments. I'm gonna ask you to unmute first because I want to hear what you have to say.
Well, we did an earlier program on this, I would say maybe about a year ago, when FLEC was still threatening. It had been, it had all been kicked down to North Dakota to make its decision, or I'm sorry, to the circuit court to make the decision. I think that was the state of the original FLEC decision from the Supreme Court. So my view of this is simply educational and interested because I'm from a state that doesn't have an integrated bar. We have our profession is regulated entirely by the highest court, the Court of Appeals, and the appellate divisions beneath it. And so we don't have the issues. We have different issues because we're constantly trying to collect dues and get members. But I'll just throw this idea out there. Regardless of the fact that bars may be successful by going to the Supreme Court or by decisions in district courts and circuit courts, it seems to me that no bar association really wants to go to the expense of defending such a case. And so I think the threat of litigation has as much a chilling effect on positions that an integrated bar will take as these decisions themselves might have. And for anybody who's in the leadership of an integrated bar, I wonder if you find that's the case.
This is Bob Kutcher. I'm in Louisiana. We got sued, and we were successful at the district court level. We are set for oral argument, whether Zoom or live is to be determined, on September the 1st, along with Texas. Our decision came along a lot sooner. In answer to your question, Sharon, there is no doubt that you think twice about what you're doing when you know you've got this breathing down your neck. The lawsuit did not come as a surprise to us. We were prepared for it. We were fortunate because through no fault of our own, we actually ended up having insurance coverage for the claim. So that made it a lot easier. And we were successful. The challenge to us was not quite as broad as some other states. I mean, if you look at the Oklahoma lawsuit or the Texas lawsuit, they're all over the board. The challenge that was directed to us was primarily our legislative activities, which we still engage in. But you do have to be careful about what you're doing, and we do Keller refunds and everything else. And so at this point, we're just waiting for the Fifth Circuit oral argument. I don't think anything's going to, as I told my board, you're not going to find a district court judge who's going to go against the existing U.S. Supreme Court law. And you're probably not going to find an appellate court, although the Fifth Circuit has become very conservative. So you really don't know. But until the Supreme Court denies writs in all of these, or they make a decision, it's hanging over all the bars' heads, all the mandatory bar heads. So that's kind of where we are. You know, we will still do legislative activities, and because as they impact the practice of law. However broadly you determine that is another question. But if it impacts the practice of law, then under Keller, we are authorized to lobby, and that's what we do.
Sharon and Robert, thank you so much for getting the conversation started. I was stuck in a separate room and they were trying to get me over here. Let me introduce myself. My name is Tina Cruz. I am a member of the Ncbp's Programs Committee. I also am currently the president of the State Bar of New Mexico. Thank you for joining this room. We are tasked with discussing what regulated bars can and cannot say in times of crisis. We have 3 questions that we've been asked to visit about, and I'm going to kick it off by asking the first, which is, did your bar make a statement during the George Floyd protests? Why or why not?
We did. Louisiana did.
And what was the nature of that statement, Robert?
For the life of me, I can't remember because there's been a bunch of stuff going on in our lives. I mean, it walked a fine line because understand our bar's got 22,000 lawyers and no shortage of really conservative lawyers, to be polite. So we crafted something that addressed the issue, but we actually generated precious little feedback. I think part of that was the fact that we were all still shut down. So there was not as much adverse feedback as would have come ordinarily.
Thank you, Robert.
So we did it.
Thank you, Robert. I saw Tara, you raised your hand. Was there something you wanted to offer?
Washington did as well. And after that, our Supreme Court put out a much bolder, stronger statement, which has been helpful because we're sort of referencing that as we move forward. Although I don't think our Supreme Court is subject to the same rules that we are, so perhaps it's a little bit easier for them to be bold. In addition to the Supreme Court case law, we also are governed by a court rule, General Rule 12.2, which tells us that we can only weigh in on matters that affect the practice of law or the administration of justice, which is a similar standard, but not the same standard. Historically, we have interpreted administration of justice quite narrowly to really just apply to things that affect the courts. And currently, I think we have board members lawyers, employees that are all wanting to push a little bit to question whether that really should be so narrow as to be speaking about courts, or whether we should also be free to comment on police practices and other sort of institutions that affect the justice system. But in our statement, we tried to really focus on the application of law in the courts and how that has been unfairly applied.
And Tara, did your bar receive any pushback from members regarding the position that was taken by the bar?
Very little.
Thank you. Anyone else have any thoughts regarding issuing statements, whether it was done or not, and why that was the case?
Tina, this is Robin. So I'm in Minnesota, and of course we're ground zero for George Floyd. So it would have been incongruous for us not to have said something. And unlike the past where we've threaded, the needle, because we definitely don't want to alienate members and get too engulfed in politics, the statement from the State Bar of Minnesota was very strong. It's the strongest statement I've ever seen them make on this kind of issue. There has been, of course, the State Bar is closed, and so there aren't the interactions that might produce a lot of feedback, but there has not been any negative blowback. In fact, I think that there's efforts by the sections of the State Bar to even go further. I'm in the criminal law section, and I know that we've been debating, even more statements and more engagement regarding racial justice issues. So I'll just stop there, but I thought it was a great moment for the State Bar.
If I can offer, even voluntary bars have that issue because we're dependent upon keeping our members happy and our members paying their dues, or else we don't have the means to succeed. So I think that there may be different issues, but voluntary bars too have to be very careful anytime you release a statement. I think one of the county bars had a big blowout because I think it was Oklahoma, was it maybe Tulsa bar? One of the bars in Oklahoma, county bar, had a huge blowout because the president had issued a statement. So that happens too. I'm sort of curious though, among the integrated bars, whether you have a legislative program and whether you feel that criminal justice reform is something you're allowed to promote in your legislative program.
Well, I'd raise my hand, but I don't have a camera working, so I'm raising my hand. Yes, and yes. We did an extensive criminal justice legislative push 2 years ago. It was the Supreme Court got behind it, and we're perfect. We've done that. I mean, we generally will take positions on criminal law bills, and we did a Reinvestment Act, I think in 2018. So yeah, we're perfectly comfortable doing that. And we actually did not get as much pushback as we did on other issues. But the primary reason for that is that the DAs were not opposed to it as vigorously as they've been opposed to some other things. And the DAs all belong to the State Bar Association too. We have had disputes with the DAs on positions we've taken in the legislature.
Thank you, Robert.
So this is Aurora. Sorry for joining late, but I want to chime in on that one. I kind of want to follow up on Sharon's comments on the voluntary bars. Yeah, Chicago Bar actually issued a statement, but particularly here in Chicago, we are very conscious of, of issuing statements like that on racial justice, on, the diversity and inclusion, on Black Lives Matter. As a matter of fact, also our Chief Supreme Court Justice, Ann Burke, is the one who's really championing or pushing for criminal justice reform here. We've always done that. Chicago Bar has been involved in that aspect of it, but having that from our Chief Supreme Court Justice really obviously helps.
Thank you, Aurora, and thank you for joining us. It's great to see our incoming NCBP president here today. Here in New Mexico, we did not issue a statement, but what we have done is created a committee to focus on some of these issues. It's a subcommittee of a larger group. We've had a committee on diversity in the legal profession since the early 1990s, and we recently created a committee on wellness, and we're creating a series of panel presentations that are going to be taking place August through October to deal with issues related to racial injustice, questions related to wellness. Last year we had a diversity survey that was performed. We do it every 10 years, and then we have a report that's issued. Those findings from the report are being finalized, and we're going to be integrating the work that was done early on by the committee into what has been happening from a racial justice perspective as well. So while we haven't formally issued a statement, we've been focusing on other initiatives that we think address the current state of affairs. So that takes us to our next question, which is, did you go beyond making a statement, such as setting up a policing task force or working with the courts? And if you did go beyond making a statement, what did you do?
Hi, everyone. I will chime in. Misha Buford-Epps from the state of Missouri. I started as the new executive director for our state bar in the midst of the pandemic. Thank you. And I'd say George Floyd's unfortunate killing happened maybe before 60 days. Before the 60-day mark. And so our bar did issue a statement, but we had significant discussions, and it probably was much more watered down than some of our membership would have liked. But it really focused on our commitment to the rule of law and equal access to justice and the impartial administration of justice, essentially. But beyond issuing that statement, what we have tried to do is focus on just the issues of diversity, equity, and inclusion in the profession as a whole. And so our president is setting up a special committee really to look specifically at the experience of attorneys of color in the state of Missouri and coming out with some specific concrete actions that the bar can take to move forward on retention, promotion, and advancement, and increasing the level of engagement and inclusion within our bar. And so hopefully that special committee is going to have a 60 to 90 day time frame to propose these actions and to help us in reinvigorating the discussion around implicit bias and inclusion in the profession. So our Supreme Court also last year implemented a mandatory 1 hour implicit bias, diversity, and cultural competency requirement. That's part of the ethics. And so that is, this is the first reporting year where that requirement is in place. It's been interesting. There's been some pushback, I'd say, on having to meet that requirement. People have not yet felt the negative implications if they haven't satisfied that requirement, because our CLE reporting year has been extended through September 30 instead of the regular June 30 date. So it'll be interesting to see how that fares as we go into the fall. But I'd say that those are the primary additional actions that our leadership has taken.
Misha, thank you so much for sharing. It sounds like your bar is staying plenty busy and has a good number of initiatives at play. Any others regarding other initiatives that you have been implementing in response aside from issuing a statement? Yes, Tara.
Thank you and welcome, Misha. We have created a equity and disparity task force, seeding a lot of the membership from our minority bar associations, and they're tasked with over the next 2 years combing through laws and regulations that relate to the practice of law and trying to identify those that perpetuate inequity so that we can propose changes to the court. That's one piece. In addition, our mandatory continuing legal education board did something similar to what Misha was talking about. They proposed earlier this year 3 new ethics credits. One would be on bias, another was on technology, and another was on, I think, addiction. And that proposal was initially not supported by our board and rejected by the court. But they're going to be coming back this fall to with a modified proposal to just request the ethics credit in bias. And my hope is that at this time that the board will support it, and I suspect that the court will be more likely to adopt it.
In New York, we've had such a rule for a couple of years, so we actually have been through reporting cycles so that people do have to report that within their ethics requirement they've taken courses on diversity, inclusion, and bias. And most of the bar associations are providing those programs free of cost to their members to encourage as many as possible to take them. We've long had various task forces from time to time, way back from Eric Garner's death. We have had a number of task forces and issues. We specifically have policy, though the legislature was not quite responsive to it until this year. We had a policy position urging the legislature to eliminate the law that protected police misconduct records from view of the public, and again that finally passed this year. But we have a brand new task force specifically on racial injustice and police misconduct, and that is new in addition to our criminal justice section that has been working long and hard on these issues for quite some time. But again, in contrast, that's voluntary bar. So no worries about the Keller rule, only worries about whether or not our members will support what we're doing.
Thank you, Sharon. Let's turn to the final question, and then of course we can continue to engage in the dialogue on the subject matter. The last question is this: is there a way for official regulated bars who are being challenged to be effective in social justice without getting into trouble? And it looks like we're going to be kicked out of our breakout room as it is.
What have you experienced either in the past or what you anticipate in the future?
Hi, this is Elizabeth Wright. I am general counsel for the Utah State Bar, and we did have, we're a pretty small bar, about 10,000 active members, and somebody from a locally known libertarian-leaning organization approached a lawyer who's actually on our board to represent them in a suit against the bar. And of course, they obviously said no, they wouldn't. That was about a year ago we heard about that, and we've in response to all the litigation that's been going on, we have been reviewing our processes and our efforts to be in compliance with Keller, but we haven't heard any more from this gentleman that approached our lawyer about starting a suit. But our bar is very much on the lookout, and would not be surprised if we were sued.
Now, Elizabeth and Doug, you both talked about kind of proactive steps from others. have you done anything, say, either with your legislature or with your Supreme Court to try to head off problems and do something proactive that prevents issues from coming up?
This is Doug, our Chief Justice and other. I'm a district court judge, so our Chief Justice and other people in the judiciary are involved in the committee, as well as lawyers, state bar, other members of the public, and looking at things that we may want to do to help in the future. So that's the only thing we've done. We've had no legislative challenge, no indication that there is one coming. It's just that Fleck lawsuit that we've had to deal with. So, but the judiciary is involved in the issue because obviously the Supreme Court licenses attorneys in our state. And so the bar is intimately connected with the judiciary.
So in Utah, under the Utah Constitution, the Utah Supreme Court has sole jurisdiction over the regulation of the practice of law. So we don't worry about our legislature directly like that. Our court is aware of Keller and some of these challenges. As you may know, our court is in the midst of pretty sweeping regulatory changes to the practice of law. And they've talked about some of those in the context of Keller and what may be coming with these Keller challenges. But our court has not been involved. It's just been our commission making sure that all our sails are trimmed and that we are doing everything we're supposed to be doing to be in compliance with Keller.
This is Pat from Hawaii. When the Fleck case was percolating up, the Hawaii State Bar Association formed a special subcommittee. And this subcommittee took a survey of the members to get the pulse of the members as to what type of services, what we could do better so we can improve our services, do more outreach with members. But in conjunction with that, we did meet with the Supreme Court, the 5 justices, and we discussed the Fleck case. And we were very pleased with the response of the court because they indicated that they did not have the funding or the resources to do what the HSBA does. So they expressed they're pleased with the current status quo. So we find that heartening. So in case we do have a lawsuit on our hands, the court is in tune with the Bar Association. But other than that, we've been extra cautious with positions that we take as a legislature, and it does have a chilling effect. So we steer away from all social issues and just bread and butter, court repair and maintenance, funding of judicial positions and certain types of staffing. But other than that, we let the sections now take positions on specific pieces of legislation which affect different areas of the practice of law.
So to follow up with what Pat was talking about there in Hawaii, as to the rest of you, what do you do and what do you feel is successful in trying to communicate with and build a relationship with your respective Supreme Courts?
I can respond for North Carolina, Joseph, and we have a really strong relationship with the court, although its oversight is fairly minimal. They approve our rules and any amendments to those rules. But apart from that, they have really limited oversight. As I said, our disciplinary program is completely separate, and it's a separate independent hearing body that's a state agency that hears our disciplinary cases. But we routinely meet with the Chief Justice. We try to make sure she's aware of what we're doing and that we don't see any problems with her. Our court has changed a lot in recent years. It used to be very conservative and now it's moved more towards the liberal end. And the court has actually used us a tremendous amount to communicate with lawyers during COVID-19 about the closing of the courts, the limited reopening, and we're kind of their opportunity to speak to the entire legal, the membership of the bar. the entire legal community, which they don't have through any other entity. So I think they're very interested in working with us. The other thing in North Carolina that I found is that the judges, and this is because of the way we're set up, the judges from the very lowest level right through the Supreme Court are really happy that we do the discipline. They love being able to report a lawyer to us and then we deal with it. And I think they're kind of protective of that approach to professional misconduct and discipline. One thing, and just a little taken off from what you're saying, one thing that we started to do, I don't know how long it's been now, maybe 8 years ago, we realized that the General Assembly, which is our legislature, was very distrustful of lawyers. There was kind of an anti-lawyer sentiment there. We did not go to the General Assembly because we saw ourselves as a state agency that we should not be lobbying, but we realized that we really needed to know what was going on there. So we have one of our staff lawyers who is our liaison to the General Assembly. He's not a lobbyist. He is just there to basically, one, make sure that the legislators know who we are and the good work that we're doing, to know whether there's some bill that's being, snuck in under the door that has some impact on the regulation of the profession, so that we can make sure our voice is heard if that happens. And it's made a huge difference, having a presence there. One, if we feel like we have eyes and ears, which we didn't have previously, but also there's a face to the State Bar. The person that is doing this work for us is a very congenial young man, and he has just put his best foot forward for us, and that has made a huge difference. So, if I have any recommendations, it's to make sure that you're paying attention to what's going on both at your court and in your legislature, to have a presence there, and so that they know who you are and what you're doing, and why you're doing it, and that you're available to answer questions, to be as transparent as possible. And I have two of my officers are in this meeting with us, Barbara Christie and Darren Jordan, so I don't know if they would add anything to that.
No, I think you did a good job of saying it.
I'll say in Utah, so one thing we have, I can't think, I want to say like 20 state legislators and senators who are lawyers. And we really try to foster a good working relationship with them, because we have found that as lawyers, sometimes they get the issues that maybe the other legislators don't. And we, every year, at the beginning of our legislative session, we have a breakfast with the lawyer legislators, just to get to know them, have them meet our board, have them meet our staff. And we have found that, when you get in a pinch, having those good relationships with the lawyer legislators has helped us tremendously.
Now, Elizabeth, I know Nate, and Nate is on here too, Nate Alder, and have seen at least one or more of the justices of your Supreme Court. Explain how your relationship is with your Supreme Court there.
I think we have a very good relationship. We meet with them regularly. Our board does, our board executive director, our president of the board, our executive director, and our president-elect of the board have quarterly meetings with the Chief Justice, just to sort of update them. Bar staff and volunteers sit on many committees with the court, that also contain court justices. We have all this regulatory changes that are coming that you may have heard of, some members of the bar took a different position, but the court and our board have gone out of the way to smooth that over and get everybody talking and on the same page. And so far that seems to be working. Our court is very amenable to rule changes that we ask for, and likewise when they ask us to change anything, it's rare, but we're happy to step up and make changes. So I'm proud to say overall we have a very good working relationship with our court.
And Nate, you seem to be muted.
Well, he's at a basketball game.
Yeah.
We still can't hear you, Nate.
Can you hear me now?
Yes.
There you go.
I'm sorry about that. I just think that bars need to be ahead of the issues. Unified bars, mandatory bars need to be far ahead of the issues, way ahead of the legislature, even ahead of the court. You know, having public interest, public members, you know, on their board, and then embracing, you know, changes to enhance public benefit, and to move away from, you know, the lawyer industry side of things and toward, you know, access to justice, you know, those kinds of things. So I'm proud of what Utah has been doing in terms of getting ahead of the issues. And I've been involved with the bar really since 2000, so 20 years on the Bar Commission. And I've been watching these attacks on the bar come from, you know, certain legislators and whatnot. And in each instance, we've been able to kind of sit down, work with the legislator, find out what's driving the issue, and then how can we get at that issue. And a lot of it has to do with cost of lawyers, people being able to represent themselves in court, you know, those kinds of issues, public issues. And there's always a solution for that kind of stuff. So the problem is that 80% of the lawyers are chasing 20% of the legal market and leaving, you know, 80% of the people behind. And that's where the courts get overrun with self-represented litigants and DIYers. And we need to solve that problem. That's our own problem. So.
Well, it looks like we've all come back together in the large group. And I hope everybody had insightful conversations with our facilitators while you're in those groups. I'd like to call on each facilitator to share some of the takeaways that they got during the breakout session. And we'll start with Tina Cruz. She was in the group dealing with what regulated bars can and cannot say.
Thank you, Joseph. Our group had a fairly robust conversation about some of the areas of concern that come into play surrounding the issuance of statements related to racial justice issues, initiatives that can be implemented as well. The takeaway for me, which was, I think, a bit enlightening, I wasn't really thinking about it in this context. As the president of the State Bar of New Mexico, of course, I'm always very mindful of Keller-related considerations. During our breakout room, Sharon made note of the fact that even voluntary bars, however, deal with similar challenges, of course. They may not be in the context of Keller-related constraints. However, there is a need to ensure that you are in some way keeping your members happy. So while those of us that operate in the universe of integrated bars have Keller to guide the path forward, voluntary bar associations likewise have considerations that come into play when issuing statements or developing initiatives. Another takeaway, which I thought was really important, related to the various programs that are being put into place by various bar associations, whether integrated or voluntary. It struck me that there's so much great work that's being done throughout the country in this particular area that creating a database for resources so that we can go and take a look at what other jurisdictions are doing, other bars are doing, would be really helpful, because I think what that ends up doing is creating an opportunity for developing new ideas and innovative programs that can be of benefit in our respective jurisdictions.
Great. Now the second group, the facilitator was Jason Long, and that was the one dealing with ensuring that all voices were heard, how to create diversity in terms of your board. Jason, I'll hand it off to you.
All right, thanks. We had a good conversation. It got cut a little bit short because your moderator didn't manage time as well as I probably should have, but it hopefully gave everyone an opportunity to speak. You know, the first question that we kind of addressed was whether or not I think we all agree the diversity of thought, diversity of makeup of the leadership of bar association is a good thing and something we all need to be striving for, but whether or not it's something that needs to be intentionally pursued and how you intentionally potentially pursue it. I think the general consensus seemed to be that if a bar association is going to be diverse in today's day and age, more often than not, it has to be a very intentional action on behalf of the leadership to achieve that diversity, however you're seeking it. And the question is, how do you go about doing that? And we had a wide range of representation in our room from people who are in fairly diverse populations, where it comes a lot more naturally. I think Lisa mentioned, it's who you know in the circles you run with. When she was president down in Arizona, it was a little more easy because she had circles of friends who were much more diverse and was able to pull them into leadership positions within the bar. Some bar associations we're talking about are very homogeneous, and it's very difficult to identify those leaders and those individuals who wish to serve. I think some of the ideas that were talked about and some successes that the bars have had in the past, the creation of a leadership program that will encourage young lawyers and new lawyers to come into a training for leadership within the Bar Association, and that gives the Bar Association an opportunity to hand select and pursue diversity. And once those individuals, and I can speak from our own state's experience, once those individuals are in that sort of pipeline of training, it becomes much easier to pull them into various leadership positions with the Bar Association, either immediately or even years down the road. We're seeing the fruits of that now in Tennessee, and I know several of the other bars that we talked about are also seeing productive results from those kind of leadership training academies. Another, one thing that my bar associations have not done, but I'm very interested in, several of the bars we talk to actually have diversity positions on their boards. So positions that are intended for and are specifically designated as diversity positions. Again, speaking from my own experience, we have the appointed positions on the board, and typically our president who appoints those positions makes a special effort to appoint diverse individuals, but it's certainly nothing written in stone. And so I was really encouraged to see that several bar associations have gone so far as to provide for those positions and mandate positions of diversity within the board, which I think is a good thing. We talked about the fact that, what are the limits of what a regulated bar can do in terms of expending resources, expending money to pursue diversity. And I think that's, certainly a question that's going to be up for challenge, or could be up for challenge coming down the line. I think the overall thought was you still have to pursue it. You still have to make resources available for it, because it's something that enhances the benefit of the bar. And then another question that we talked about were the types of diversity that we should be pursuing, not only in terms of racial, ethnic, gender makeup of a board or of leadership positions, but also diversity of thought. I think the thought amongst our room was that people who are engaged in bar associations and who are engaged in leadership of bar associations tend to be, not always, but tend to be a little bit more on the progressive edge of thought leadership for the bars, as opposed to the people, for example, and Janet pointed this out, that the people who are against the concept of regulated bar probably aren't going to be devoting a lot of time and energy into being in the leadership positions of the regulated bar. So reaching out and making sure that those voices are heard and those voices are a part of the conversation is a critical component to establishing diversity within the organization. I was a little bit of a unique individual to be leading the workshop on this, because my primary bar is actually a voluntary bar. I practice both in Tennessee and Kentucky. Tennessee is voluntary and Kentucky is regulated. And within a voluntary bar association, the push for those diverse opinions is much easier, quite frankly, because it's really a market force for us. We cannot alienate those voices that disagree with the majority of the bar association or the majority of those active in the bar association, because if we do, we risk losing those potential volunteers and those potential members. So just as a matter of market consciousness, we have to make sure that the positions we take, the issues that are discussed, that they hear from all diverse viewpoints so that we can encourage attorneys across the state to join the organization. Obviously not a concern in terms of driving membership for a regulated bar, but at the same time, for the strength of the bar and for the strength of all opinions to be heard, we think reaching out to that kind of diversity is something that regulated bars should focus on as well.
Good. Thanks, Jason. Now, the third group was it was a continuation of the original presentation and the current challenges for regulated bars. There was actually a consistent theme throughout what everybody was saying in that group. Both in North Dakota and in Michigan, there was talk about trying to make sure that they were proactive and out in front of what was going on. And this could be as basic as putting together a task group for the state bar to look at those issues. In Hawaii, they did a survey of the membership, asking the members what they thought about issues and getting the feedback from them. But again, they were getting out in front. And then Nate got on, as well as Elizabeth Wright, in terms of Utah's bar and their relationship both with their court and their legislature, and trying to get out in front of both any issues that would come up with the legislature or any issues that would come up with the court, so that they're addressing those issues prior to them actually becoming in any way problematic. But getting out there and understanding what they are, and then if there's somebody that you feel that is going to want to challenge what's going on in the bar, to find out the basis of why are they concerned about that, what's the basis of their challenge, and try to address that. So it was a real good discussion that way. So we've got just a couple minutes left here, and what we haven't done is allowed, and this is kind of off script, Janet, if you have any last thoughts or words, and then the rest of you folks, if you have some questions for Janet, we really haven't allowed an opportunity for you to ask her questions. So just for a couple minutes here, if you have any questions, and Janet, if you have any last comments.
I'm really tired of hearing my own voice, so I would love to just sit back and hear other people's voices, and I'd be happy to respond to anything that might have been provoked by the presentation or the conversations.
Janet, I have a question for you. This is Joanna Scavone. I'm president of the San Diego County Bar Association. And so I'm not at a state bar, but with 10,000 members, we're a metro bar, but we're the size of some state bars. But we're obviously voluntary. And you said something in our breakout room that I thought was quite remarkable, that with the current state of affairs in Michigan and the sort of governance push and pull, that there is a question as to whether you are allowed to spend member dollars on diversity initiatives. And I found that quite remarkable, and I wondered if that trickled down to even a policy level. So one of the things we've done in San Diego, and I didn't have a chance to say this in our breakout room, is we adopted at the most basic level a policy that we have to have diversity in who presents at our bar, because we think it matters who you present as an expert, right, in a CLE. So we require actually 25% diversity, and we've divided diversity very broadly. But in another 2 years, it'll go up to 50%. And if you don't have 50% diversity in a speaker panel, the program doesn't go forward. So is that the kind of thing you are prohibited from doing in the state of regulation of your bar association at a policy level?
So we don't have, we have not been formally challenged on that, but in general, regulated bars have been challenged, as sort of the chat indicates in some of the complaints, on the use of compulsory dues for diversity and inclusion efforts. So anything that would look like or could be characterized as sort of an affirmative action response, I think, is something that gets swept up in the First Amendment arguments about what integrated bars may or may not do.
And so that trickles down to even having policies that you want to have an inclusive speaker set.
I think we have within our strategic plan a plank about diversity and inclusion, and our bar has, for example, promoted implicit bias training and worked with the Prosecutors Association of Michigan in that regard. So we advance our strategic mission, but we're mindful of the fact that that element of what integrated bars, regulated bars can do is subject to challenge. So we're watching that piece of the challenge.
This is Bob Kutcher. I'm in Louisiana, we got sued, but it was just on legislative activities. But if you look at Texas and Oklahoma, those lawsuits were much broader, and they included allegations regarding diversity programming as well. So it is fair, depending on the not-for-profit that's bringing the lawsuit, it is fair game in terms of a challenge.
Interesting. So we're coming up at the close of our hour here. And again, I'd like to thank Janet for being our speaker today and being our source of information. We really appreciate it. I also want to thank Teresa Peavy, Tina Cruz, and Jason Long for putting this together. And I want to thank all of you for participating today and helping us in this discussion. At least a portion of this program has been recorded and will be available on the Ncbp 21st Century Lawyer webpage in the next week sometime. And for more innovative programs and discussion with other bar leaders like you did here today, be sure that you register for the 2020 Ncbp virtual annual meeting. That's going to be held August 25th through 27th. Meeting information and registration, you can find that on the Ncbp webpage. So again, thank you for everybody for participating. We really appreciate you being on today. Thank you.
Thank you.